I will now call case number 124607, State of Kansas versus Miles Martin.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Miles Martin. Madam Chief Justice, may I have 3 minutes for rebuttal?
3 minutes is granted. Thank you, Mr. Dunn.
Thank you. This appeal comes before the court following Mr. Martin's convictions for simple possession of methamphetamine and possession of methamphetamine with no tax stamps affixed. My plan tonight was to kind of flip the original orders of the issues as they were presented in the Court of Appeals and present them in the same order that was in the petition for review, to talk about the lesser included offense issue first. And if time and if the court, of course, as always, if the court directs, to talk about the suppression issue, time permitting, but anything we don't get to, I would go ahead and submit on the brief. And with that, I'd go ahead and move into the lesser included offense issue. I've been around long enough to have watched the evolution of this, from the abolition of FICE in 1998 through the recurrent recod. And basically in Kansas, lesser included offenses are covered under KSA, it's statutory, KSA 215109. And 215109A allows the prosecution of more than one crime based upon the same conduct. However, subsection B says if one of those crimes is a lesser included offense of the other, then only one conviction may result. And that's where we have the problem in this case. The remedy for this has always been that the court enters a verdict as to the greater offense and the lesser included offense effectively goes away. So what are lesser included offenses? And as I was one of the participants in Schoonover, I can tell you that we look at two specific places that are relevant to this case, subsections B1 and sections B2. And B1 doesn't at first glance apply to this case. B1 says a lesser included offense is a lesser degree of the same crime. And I'm going to come back to that in a second, but section B2 is when a crime where all of the elements of one of the crime are identical to some of the elements of another crime. And that comes into play here.
Don't you shortchange yourself on the way you just, I mean, don't we, let's go back to the exact wording of the statute, because that's where a crime where all elements of the lesser crime are identical. And to me, the lesser crime stands out as a separate term, which I think is your argument.
Well, if that were the case, then that would make subsection 1 somewhat redundant now. Because subsection 1 actually cares about the degree of the crime, which is an implication of the lower severity level of the crime. Subsection 2 is only concerned with the elements of the crime. That's all that matters.
Is that true if you consider that subsection B2 lesser crime to be still referring to a lesser degree, just not of the same crime as in 1, but as of a lesser degree of a crime with some of the elements?
I would say the plain language, my response is the plain language of the statute lacks the word degree. It lacks the word severity level. Nowhere is that present. The only word is lesser. And to me, it seems the most reasonable definite reason that it says lesser is because there are fewer elements. There are fewer elements in the lesser crime. The greater crime has more elements. It has all of the elements of the lesser plus some more. And that comes into this case, for where we're going with this, This case should be exactly the same as Hensley. The twist, obviously, and that's where the Court of Appeals had a problem with this, was exactly what the court's pointing at, is this is a weird twist because the greater offense in this case is the tax stamp violation. All of the elements of possession of methamphetamine are contained within the elements of possession of methamphetamine with no tax stamp. There's no way to possess meth without a tax stamp without first possessing meth. So it's as simple as that. Now, the twist, of course, is that possession of methamphetamine with no tax stamp is punished less severely. One is on the drug grid, simple possession of meth, whereas the other is on the non-drug grid as a severity level 10 and has lower punishment. But it's our contention that that's irrelevant. Nowhere in subsection 2 is the punishment or the severity level of the crime.
So you're
referred.
saying that the meaning of the lesser crime is the same as the meaning of any crime?
No, lesser refers to the number of elements in the crime. There are fewer elements in the lesser crime. The greater crime has more elements. It has all of the elements of the lesser plus more.
Wouldn't that also be true if you said any crime? A crime where all elements of any crime are identical to some of the elements of the crime charged, because it's defining a lesser included crime.
I think that the problem I kind of have with that is that pushes us into another statutory subsection. I think it's subsection G, where we talk about identical offenses. There when you're talking about any.
No, they're not identical because one only has some of the elements of the other crime.
Yeah, okay. Taking that into account, if, as a fallback on this, if that is the case, then certainly we're talking back and forth about this. That certainly seems to imply there's some sort of ambiguity there. If it was plain, it would say a lesser degree or the word severity level would be in there. And if there is an ambiguity because it's a criminal statute, it has to be construed in favor of criminal defendants. So therefore, my interpretation should be the interpretation that prevails in this case. Undoubtedly, opposing counsel is going to follow along with the court's argument here. However, I still think the plain language of the statute is what controls. When you talk about degrees, the legislature showed it knew how to discuss the degrees of crimes. It used the words a lesser degree of the same crime in the first one. It could have said a less severe crime, crime where all the elements of the less severe crime are identical to that. If it wanted to limit it only to the situation where it was a crime that had a lower severity level, but they didn't do that. That is our position.
Counsel, as much fun as it is talking about statutory interpretation, I do need to move you over to the suppression of the methamphetamine question. Here's my problem. You want us to take a snapshot of the evidence as it existed at the suppression hearing to decide whether the district court correctly decided the suppression issue, right?
I believe so.
My problem comes from the contemporaneous objection rule and the fact that in order to preserve the challenge, the objection to the evidence coming in to the jury required the defendant to make an objection at trial, which the defendant did. But the snapshot of the evidence that should occur at trial ought to include everything that's happened before that objection is made at trial, which would include a larger universe of facts than the snapshot you want to take at the hearing. I understand what you're trying to do, that hearing, it looks like the state missed a couple steps in the process, and so did the district court. But it seems to me by the time you get to trial and you take that a snapshot of the evidence available to the district court at trial, there's a larger universe and there is enough factual basis to overrule the objection. That makes sense?
Well, I think before we even get to that point, we have a problem of whose burden this was to begin with. Once the defendant raises a Fourth Amendment, Section 10, Kansas Constitution challenge, the burden shifts to the state to produce an exception. And what were those exceptions the state cited? State never cited search incident to arrest.
I understand all of that. And I get that. I just don't understand why, when the objection is renewed at trial, we can't take in everything that happened.
Right.
Prior to that objection being made. Regardless of who has the burden. You're right, states, let's give the state the burden on that. There's still enough facts to overrule the suppression objection at trial. And it's the objection at trial that matters.
I think, again, our position on, that I'm trying to mention is that you can throw out all the facts in the world, but it's not the court's role to pick and choose from those facts what Fourth Amendment exception applies. And
But a Jackson v. Deno hearing, which is what this was, to determine whether there was, whether this evidence can be introduced at trial, is not even required before trial, is it?
This isn't a Jackson v. Deno hearing. That's a Fifth Amendment.
Oh, I'm sorry.
Sorry, I'm not.
But
This
isn't
is a
this
Fourth
really,
Amendment
isn't
situation.
this much like a motion in limine where you really, in order to if you introduce the evidence at trial inappropriately, it's going to be reversed. And here, if it was introduced appropriately, then all of the facts at trial, to Justice Biles' point, means that it is cured.
I guess I think we're talking past each other and I'm missing exactly because I'm not seeing, it's not a motion in limine.
No,
That's a different thing.
no,
We're still talking
but-
about a
right,
suppression, a Fourth Amendment suppression situation, which is
right,
different than Fifth Amendment jurisprudence on this.
right. But the important thing is that the evidence at trial is legitimately presented.
Assuming if it's presented and cited in support of the ground that was provided and the district court rules on it that way.
Right.
So what mistake are you saying the district court made at trial when the objection was made by the defendants to suppress that evidence?
I don't think there was an adequate citation to the appropriate ground. And
Before you sit down,
perhaps I'm not, I was thinking it because that was something that hasn't been raised before. I hadn't thought about it completely, and I can, while opposing counsel's up, I can take a look.
before you sit down, why isn't this a consensual search? She handed over the pill bottle. She wasn't forced to hand it over. She gave it to him. Does that exception come into play here?
No.
Why not?
Well, the state's whole proposition is that he was in custody at the time and under arrest, and your whole element of consent
Yeah.
ceases to apply in that situation. A reasonable person, once they've been detained by officers and they're told, give me, so what else do you have on you? Do you have anything? That is not a voluntary relinquishment of those items at that point in time. When a police officer tells you, what do you have on you? And, oh, is that it? Because it wasn't even the first time, it was the second time. And technically this was, if you want to call them all searches, you had an initial pat down by the other officer. Then, which should have taken care of all of this to begin with, but then you have another, oh, well, she was going to put him in her patrol car because he was warm. And then there was an element of this little dog involved somehow. But yeah, okay, well, what do you have on you? Here's my cell phone, my wallet. And I don't know if there's another item. Oh, is that it? And then, okay, here. Clearly, it wasn't do you mind? There was no saying no. Is the short of it. And that happens, and I believe the case law supports, once you're in custody under arrest.
I'm fine. Thank you.
Can I take you back to your multiplicity argument, counsel? If this court doesn't agree with your interpretation of the statute, do we still apply our traditional multiplicity analysis under Schoonover, or do we have to incorporate, how do those two things fit together? The Schoonover test and subsection B2 of the statute, if at all?
I think I'm not sure what to think. I think they dovetail exactly together. You look at the elements of one, are they fully contained in the other? It's severity level of the crime is irrelevant on this. I think the more interesting question comes to remedy, because the statute specifically says only one can go in. Now, my point on that is we should follow what the law has always been, and it's the greater that stays, which just so happens to benefit my client in this situation. And that's what we have always done. I went back to try and find if there was ever a situation like this. Typically, you go back to these lesser degree things. It really goes back to homicides, specifically with felony murder and merger with that. But I was unable, and I went back quite a ways to find anything wherever they said, oh, the court can just arbitrarily choose whichever one he or she wants to keep in that situation. It has always been, and pick 6809, I think it is, says this is what you do. Granted, pick is not a court holding or the legislature, but it's just recognizing what this court's always done. And I think it's kind of odd, and it certainly is not particularly becoming to say, no, we just always want to give the hardest possible thing to the defendant in this situation, when you should follow the rule as it's always been. The greater offense is the one that remains, which again, in this case happens to be the less severe one.
No other questions? So thank you, Mr. Gunn.
May it please the court, Chris Elslager appearing on behalf of the state, making another of my recent string of relief pitching appearances, meaning I came into this case very late after all of the briefing had been done, the petition for review had been granted. So I have that kind of unsettling feeling of coming into the game with runners already on base. And so I hope that I can adequately answer your questions. Keeping with my analogy, we'll see if I can throw some strikes. Fundamentally, the statutory interpretation question, when you look at KSA 21-5109 B2, it says, a lesser included offense is a crime where all of the elements of the lesser crime are identical to some of the elements of the crime charged. Well, what's critical here is the word lesser. Lesser means something, right? The legislature doesn't put in meaningless or superfluous words. So what does the word lesser mean? Well, just what the Court of Appeals said it gave it, ordinary words get their ordinary meaning, right? It says rule of statutory construction.
Well, the dictionary definition, counsel, of lesser can mean fewer, or it can mean, I don't know how the ordinary dictionary definition of lesser clarifies it necessarily, because it could mean fewer, which supports your opposing counsel's argument, but it could also mean less severe too, which would get to your interpretation of the statute. So is it ambiguous? Do we have to resort elsewhere, or what is there additional language around the statute that clarifies?
Well, I mean, first I'm just saying the common sense meaning would be the same meaning that the Court of Appeals applied to it, is the less severe crime. I mean, it's a bit strange to say lesser equates to number of elements, because there's lots of, crimes of varying degrees of severity have fewer or greater numbers of elements. Murder is a rather simple crime when it comes to elements, although there's some crimes, some white collar crimes that might have multiple complex elements, and because I just heard his argument sitting here. I can't pull any off the top of my head, but I'm sure that there are many crimes out there that have more elements than the crimes of murder, and no one would argue that murder is a lesser included offense of those crimes.
So if you look at subsection B1, it says lesser degree. And you look at subsection B2 and it says lesser crime. And your position is that under B2, lesser crime is severity level.
Yes. Then
what does lesser degree mean in
Well,
one?
As we know, not all crimes have degrees. Only some crimes have degrees, and it's changed over time. But the one that obviously comes to mind is murder. You have first degree, second degree murder. And honestly, right now, as I say, I can't think of any others now that have degrees. I think historically some may have, but off the top of my head, I can't think of any. But that would refer to those crimes that clearly have defined degrees. And in the case where you don't have defined degrees, well, then you look to a lesser included offense is a less severe crime. It really,
So it's your position that B1 only applies to first and second degree murder?
or any crime where it's defined in degrees. And just like I said, off the top of my head, I can't think of others. That one comes to mind. We could pull the statute book out and search for some, but I mean, there may be others. And it may be a vestige from the past too. There may have been, used to be other crimes with different degrees that have changed over time. But obviously murder still has degrees. So that part of the statute still has application to crimes of murder. The second section, the one.
Then if lesser crime in subsection B2 means severity level, then what does the reference to elements mean?
Which reference to elements?
A crime where all elements of the lesser severity.
Well, that's for making that's so you can compare the crimes, because obviously it has to be it has to be included in the crime. So again, theft is not included in rape because the elements are completely different. That's talking about the substance of the crime, not the number of elements. I mean, you're really straining logic to equate it to the number of elements. I think the common sense approach is the less severe crime. And this isn't the first case where this has happened. There's another one, State v. Morones, is another Court of Appeals case from 2015, where again, they said when determining whether a crime is a lesser crime, courts should look to the severity level of the crime, and that makes sense. And it makes sense here when the other aspect of this is when it comes to these lesser included offenses and the aspect of the double jeopardy clause. There's language in the case law that says you look to see if the legislature intended to basically make multiple punishments or multiple crimes. And here you have really two separate crimes. You have possession of the methamphetamine and you have the failure to pay the tax. Those are two separate crimes. Now, yes, they share some of the elements, but they don't share all of the elements.
But can you have one without that? Can you have the crime of not having a drug stamp without possession of meth?
No, surely you do have to have the possession of meth, but it's not a lesser than, because the legislature thought this through. They made possession of methamphetamine the more serious crime. It can't be a lesser crime of the less severe crime. That doesn't make any sense. That's why.
If we're convinced by your argument, do we have to overturn Hensley?
No, because Hensley is distinguishable. And you can look at the way the Court of Appeals distinguished it here and the way the Morones court distinguished it. Because there, the possession of marijuana was less severe than the possession with the tax stamp, or possession without the tax stamp. It was a felony without the tax stamp, but simple possession of marijuana was a misdemeanor. Here, it's flipped, which again is why I think the legislature did this intentionally, because the legislature intended to punish two separate things that are related, but two separate crimes: the possession of methamphetamine and the failure to pay the tax. Of course, the only way to prove the failure to pay the tax is to show the person has the methamphetamine and no tax stamp. But there's an extra element, the no tax stamp. So
You agree with the
counsel-
outcome in Hensley, but you say it's distinguishable because it was possession of marijuana, which is a misdemeanor.
Yeah, again, and it's the same argument. It's a severity level thing. The reason that Hensley is distinguishable is because the crime that had all of the elements that were included in the other crime was a lesser crime. It was less severe than the possession of marijuana without the tax stamp. Here, the possession of methamphetamine without the tax stamp is the less severe crime. So the more severe crime cannot be the lesser included because it's not lesser. I mean, I'm hinging on basic English. I mean, that is my argument. And I think it's really strained to suggest, I don't think I've seen any case anywhere where lesser included offense has been defined by the number of elements. Because obviously different crimes have, the number of elements is just the number of substantive things that need to be proven. It has nothing to do with how severe a crime is.
Well, it's not
But it's-
merely number of elements, right? It's
I'm
like,
sorry, I can't hear you.
it's not merely number of elements. It's like the nesting doll phenomena where one is entirely included within another. And my question specifically is, doesn't the legislature's choice of these two words suggest that number of elements is important? They first talk about all elements of the lesser, and then they refer to some elements of the greater, the crime charged. Doesn't
Right.
that force us to, just as a matter of sort of logic, conclude that one, the two crimes share elements A, B, C, and the greater crime has element D also?
But there's nothing in the statute that ties lesser to the elements. The elements just shows, as you said, which crimes are nested together. If they didn't have, if severity didn't matter, then the court could have done what my opposing counsel did when he got up here and started his argument. He said he left out the word lesser and just said the other crime, any crime. They could have used that word, but they used a specific term. They used lesser, meaning less severe crime. Now, to be an included crime, that's where you look at that's where the elements comes in. Is it included? Are those elements included in the other crime?
But
Lesser,
aren't those elements included here? Isn't possession included in the tax crime?
yes, but it's not lesser. You
Well,
have
let me-
lesser and included.
I understand you want to hang your hat on severity level, but back to the statute. If we skip over subsection 1 and just try to read the previous sentence in conjunction with subsection 2, it says a lesser included crime is a crime where all elements of the lesser crime, and I'll stop there. Do you think that lesser included crime is the same thing as lesser crime?
No, I think both terms mean something.
So you think,
Lesser and included
is that,
mean,
I guess my question is just, that doesn't strike me as a natural reading of that sentence would suggest that when the sentence starts, a lesser included crime is a crime where all elements of the lesser crime, that basically we can infer that that second phrase really is lesser included crime.
yeah, I mean, I think it has to be both lesser and included. I mean, it can't be greater and included. A greater crime can't be included in the lesser crime. You have to read the two terms together. Does it, okay. Am I answering your question or am I lost?
Well, and don't we also have to in reading those together, recognize that the only two places where lesser is used without the term lesser included is when the reference to a lesser degree in 1 and the reference to a lesser crime in 2, which can that be read to mean that the lesser in 1 is and the lesser in 2 are referencing the same terms, i.e. lesser degree of crimes or lesser severity level.
Yes, yeah, I think that, I mean, it does define them as lesser and it says a lesser included is, but then you're right, in the next subsections, it just talks about the lesser degree or the elements of the lesser crime are, then of course, they read back are included in the greater crime. But I think lesser means something. And I think you have to, I think, give it its ordinary meaning, which would be just as the Court of Appeals found in this case and in the Morones case, the less severe version of the crime. And if I've beat that horse to death, then I will move on to the other issue. Are there any other questions on that one? All right, the search issue, I mean, first off, it seems to me to, from the state's point of view, is almost, almost shut. I mean, there's plenty of case law that says that the a search incident to arrest doesn't, it doesn't have to happen after the formal arrest. It's kind of putting form over substance in that case.
Counsel, I understand that's the exception. You're arguing that in this case, law enforcement did not need a warrant to search because the search was incident to arrest, meaning that those two things, the search and the arrest, happened in reasonably contemporaneous time. But the evidence to support that exception didn't come out at the suppression hearing. It really came out at trial. And federal courts, federal appellate courts look at the record in the entirety, including the trial evidence, when a suppression order is challenged. I don't know that our court has taken a position on that before. So first of all, do you agree with the evidentiary assessment I gave you? And if so, how do we approach the review of the evidence in an appeal like we have before us right now?
Okay, well, this is where me coming into this case so late is going to be a challenge for me. I guess from what I've heard here, I would fall back on the contemporaneous objection rule, in that if, at the suppression hearing, if insufficient evidence was there to support it, but the court allowed it anyway, or said I'm going to allow it anyway, and then you get to trial, well, there then has to be a contemporaneous objection at trial at that point, because you never know. I mean, the state may decide not to try to introduce it or whatever. Once it's introduced at trial, there needs to be an objection at that point, and then the court can consider all the evidence in front of it to determine whether it's admissible, because we know whether it's a motion to suppress or a motion to eliminate or whatever.
Counsel, I'm just going to interrupt you very quickly, just because I think the facts let me just clarify what the facts were, that it did come out in the preliminary hearing. Okay, she did say that she put him under arrest right afterwards. Okay, so it came out in the preliminary hearing. Right before she was going to testify on the stand, counsel for the defendant said, I would like to renew my motion to suppress. Okay, so before she testified.
Okay.
And this was a different judge from the preliminary hearing and from the motion to suppress. And the judge looked at the papers and said, I'm going to deny it based on the ruling on the motion to suppress before. And so then she testified, I arrested him. She testified to facts that would support the requirement that the arrest followed shortly after the search. So in responding to Justice Wall's questions, at least that's how I understood the record contained the facts. So go ahead with that.
Okay. Well,
and
again, I'm going to say that all of the evidence should matter, and ultimately, there is an old axiom of appellate practices that the district court can be affirmed for any reason. If it got to the right result, then it should be affirmed. And if there was a factual basis to support a search incident to arrest, then the district court got to the right conclusion, regardless of how it got there. And so I would ask that you affirm on that basis. But I said, unfortunately, I can't. I'm a bit at a loss to discuss the specific facts, because I came into this so late in the game that I had no. I'm not that familiar with the actual record of the preliminary hearing and the motion to suppress.
Thank you.
And if there are no further questions, that concludes my argument. Would ask the court to affirm the district court and the Court of Appeals. Thank you.
Thank you. Mr. Dunn, you reserve 3 minutes.
I sincerely hope I don't take that long. First, I guess the main reason I was going to get up, and apparently Justice Standards beat me to page 75 in the jury trial, which I had forgotten that the continuing objection happened just before her testimony. And I think my position would be that's when the snapshot is taken. Because how are we supposed to know what the district court considered, what went into it? If things that happened, say something was mentioned in a motion for a new trial later, certainly that wouldn't be something we would consider. I think.
But why would we suppress evidence when there is evidence in the record that arguably at least would support the search as lawful? Let's just say hypothetically, just based on the timing of the objection.
I guess that's, I don't know that you really want to get me started on feelings about the contemporaneous objection rule in general, particularly when there's a pretrial hearing on the matter. But if we have this rule, and the whole reason we have it is because we want to know if there's another judge that gets a second chance to look at everything, that's what happened here. And that happened before this subsequent evidence came in. So logically, under our jurisprudence with the contemporaneous objection rule, that's when the snapshot should be taken. We're not federal courts. Federal courts have different things. They have plain error. We don't have that in Kansas. Federal courts have different rules on this. And the way it's developed with jurisprudence in Kansas, we care deeply about the contemporaneous objection rule. Therefore, it's only logical that that's when the snapshot is taken, which was before any of this other evidence came in at trial. So hopefully that explains my position on that. Couple things to go back to touch on, just because opposing counsel mentioned, he mentioned that murder has fewer elements than other things, and therefore that somehow is relevant. The thing is, though, when we talk about lesser included offenses with murder, we're actually talking about subsection B1, because they are all lesser degrees at the same time. There's not an identity of the elements with voluntary manslaughter or these other homicides. And quite frankly, that's why we have, because I don't know of a lot of other things that are other than the batteries, where you don't have the identity elements, where you actually look at a lesser degree of the same crime. And again, the problem here, I think, is that there's different grids, not so much as the other things. And I think when you have these different grids, you're in an apples to oranges situation. So I think you're stuck with still just a strict identity elements when you're doing an analysis under subsection B2. And sorry to jump back, I forgot one last thing on the search incident to arrest. With respect to the fact of an arrest happening at all, I think there's a big danger of bootstrapping in whether or not there was going to be an arrest at all. Certainly after you find 17 grams of methamphetamine, there's going to be an arrest. But prior to that, the only crimes that there was probable cause of were open container and an improper, non-functional tag light, which is a traffic infraction. And importantly, open container is a misdemeanor. And the rules for arrest for misdemeanors are not the same as they are for felonies. And I would point the court.
Drug paraphernalia.
Excuse me?
Drug paraphernalia too, right?
That's a misdemeanor also.
Misdemeanor, right?
It's use. It's drug use paraphernalia, straw.
Right.
Sorry, I forgot about that one. But it doesn't change the calculus because we're still talking about misdemeanors. And my point being is a notice to appear is, and there is one of the foreseeable results of a misdemeanor. And there are restrictions listed in 22-2401C. I know it's in our statute regarding the rules regarding arrests. There was no danger of him not being apprehended or a loss of evidence, and it wasn't a battery, and I'm missing one of the other exceptions.
So I don't really understand what you want us to do with
I'm
that, because
saying-
that's a factual question. So are you saying because they didn't argue incident to arrest at the original motion to suppress hearing? I mean, I don't, that they
That's
waived
my
it?
biggest thing is, yeah, we have, we can't look at these things later when we don't even know, we weren't.
But what do we do with that? I mean, we
It was the
can't make a
state's
finding.
job at that
I'm
point in
sorry?
time. It was the state's job to raise the issue at that point in time. They raised it in terms of he didn't have a privacy interest and it was, or consent.
Okay, so you're saying that okay, what did I just write down? That bootstrapping about whether there was going to be an
Oh.
arrest at all. That's what I want to know. What do you want us to do with that?
Oh, with the fact of just whether.
No, I
it's a search
understand your
engine to arrest
position.
At all.
But what do you want us to do with that?
Oh,
Because that's a factual question.
that therefore it's not, well, we know what the facts are, that it was misdemeanors. There was no felony in play until after this search. And the fact that an arrest happened, it's, I think if you look at was it Khan, I believe, where you had two, and this, it's, I think that's
Well,
what
her testimony was she shook it and he said it was an antacid pill or something like
it
that.
was, the bottle was.
The bottle was,
Yeah,
but
from
that
a-
it sounded like, you know, pieces of glass, that it didn't sound like, you know, based on her, you know, experience, it didn't sound like that. You know, so I don't know that there's much that we can do with that. I mean, that's what she testified to.
The
I just
fact-
said that this bootstrapping thing, I don't know that there's anything we can do with it unless I guess you're arguing that because they didn't raise the incident to
what I-
arrest and there, you know, that you would have argued there wasn't going to be. an
The arrest has to be the product. The search engine to arrest has to relate to what there was probable cause to arrest.
Right.
That's what Khan tells us because
Right.
I'm sorry if I'm butchering it. I think that was where you had, the individual had no driver's license type situation. And then the officers later searched him and found drugs and the court.
So what
said-
did, yeah, what
And
did
there
the court
was no
do?
probable cause to go look in the car.
So they reversed
For
the,
search incident to arrest on that.
so they reversed the motion to express?
That one, well, but the problem was it happened in an automobile and the court said because there was probable cause for the initial offenses that were not the drug offenses, then the automobile exception applied and that cured the fact that it wasn't a search incident. It wasn't a lawful search incident to arrest. So it explained law on that and gives guidelines to a search incident to arrest, even though the evidence still was able to come in because it fell under the automobile exception. If that's clears it up, where I was going with that.
I have a question and I think I didn't articulate it very well before, but I'm going to take another chance at it. Okay, what if we assume for purposes of the argument here that the first hearing, the suppression hearing, the state had a certain theory and they presented the evidence that they presented. And that's the end of it. And that wasn't enough. But they thought it was enough the first time. Then the judge says, no, I'm gonna, makes a ruling. It's incorrect. But then the state says, well, wait a minute. I think I need to present some more evidence in case there's a different theory. Would the state have been able to ask for another suppression hearing before the trial?
No, there's case law on that. So there's a law of the case problem there.
You can only have one suppression hearing
One by
and you
the
can't present any more evidence later on.
the case is escaping me. It was a state's appeal.
One shot, one bite. And that's it for-
Basically, you get one bite, because that's exactly what the state did. The state did it. It actually even went up on appeal and they said, oh, wait, no, we're gonna go back the second time around and raise this. It should have been under this. And the court said, no, you get one bite of the apple on this. The issue is the Fourth Amendment, whether it was a valid search or seizure, all or nothing is the rule on it. Kind of like, I make an analogy to a successive 1507. You get to raise the issue once, you don't get to come back and over on it.
Thank you.
Any other questions? Thank you, Mr. Dunn.
Thank you.
Thank both counsel for their arguments tonight. The court will take this appeal under advisement.